Probably the thing that gets confusing for a lot of clients is when they see the term terms and conditions in a contract. It's not something that the general public usually sees, and if they do see it, they kind of skim over it because they know they're not going to understand it anyhow because it's legalistic. So what I try to do, I try to leave the word terms and conditions off of that part of our agreement and just go into it as part of explanation and continuation of the work statement. And again, the work statement that the practitioner is promising should be clearly stated with no open uncertainties nor any incomplete statements. And I think that's the hardest part for me when I work with an attorney preparing my agreements, because I want to make sure I'm not misleading my clients and I'm giving exactly what I promise. Vagueness, inconsistencies will be interpreted against you if there's a dispute with the client. And I can tell you that certainly if you ever have to go to arbitration or court, you will lose if it's vague or inconsistent. Highly suggest that terms of art be clearly defined in the contract. And again, the ones that you use every day, the clients have no idea about is words like funding, vesting, basis, insurability, etc. I basically have a list of definitions for them in the agreement, so they know exactly what they are, and basically I take that list by looking at the various materials that I've done in the past to say, okay, what kind of words did we use that I may understand, may make a lot of sense to me, but maybe my client doesn't understand. And I find that any words of art generally should be defined. And they can be in layman language. They should probably better in layman language rather than legalistic. Third parties, beneficiaries, relatives, and dependents of the client may have legal rights based on the contract you have with your client. They may be in their own right enforce a contract if the contract expressly provides them a right, or the contract purports to prefer benefit on them. And quite honestly, I've had in my career more problem with beneficiaries than I have with the clients, and it's usually not what I did, it's what the client did. For example, a client may give something to one of the children over that they didn't give to the other siblings. Well, I'm the one who blamed for it. Or it might be where a husband and wife agree that their children really don't need anything because the children have all been successful, but they like to leave it to grandchildren. Again, the children get upset and they blame the financial planner. So realize that if the beneficiaries, any type of close relative and any dependents, probably going to have some rights resulting from that agreement you wrote up because of the information that your client wants to have covered in their financial plan. Another one that's important is performance. There must be a specific end date of the performance. It could be a calendar date. It could be a completion of an event within a specific time period, but there should always be an end date. I generally have the agreement for a year with an option for us to be able to renew it. And the renewal, it can be done by both parties. There are times where I find a client that is not easy to work with. They're constantly calling me. I've had clients who called me at 3 o'clock in the morning who are older and wanted information. And I would decide at the end of the year that, quite honestly, they outgrew me. Their needs were a lot more complex than I could handle. And I suggested they see another financial planner, so I don't want to extend the agreement. And there's clients who didn't want to extend the agreement with me. So if we don't want to extend it, that's fine. But I try to have a year contract so that we always have a definite date. If we have open dates such as when they've completed their retirement plan, well, who knows if they've ever completed the retirement plan, or if they carry out all the actions of the financial plan. Well, again, what's all the actions? It doesn't really mean anything. There can also be a best efforts or completion performance requirement in your contract. I like the best efforts that we'll work on, as opposed to we will complete ABC, because again, it's so hard to find what is completion of the item. We talk about such things as an estate plan that changes really over your lifetime. We talk about savings for retirement that'll change as you go along. We talk about budgets. Budgets are continuously changing, especially if the income changes or the inflation rate changes. So there's so many things involved. Best efforts is the best way of going. It's also probably the best for the practitioner, because a lot of times what clients think is needed to complete the effort is not the same thing as you think it is. Let's talk about something that is also a concern to me, and this is defenses used by either or both parties, and we're going to discuss all of these: mistakes, incapacity, duress, undue influence, unconscionability, misrepresentation, fraud, and frustration of purpose. Now, one of the things that I find most financial planners know all of these, the one they get confused with is undue influence and influence. Undue influence is significantly different than influence. Everybody has an influence on everybody you run into. People you work with, people you know, socially, your family members, there's an influence on each other. Undue is influence that is not proper. And one I can think of is children saying to their grandparents, "Grandpa, I'm not going to visit you if you don't put me in your will for $5,000, or just making up a number, or I'm not going to visit you if you don't leave your car to me." And so the grandparent feels that they're obligated to give the car to the child or grandchild, or give the money to the child or grandchild in order to have them visit them. That could be considered undue influence. Now, the cases have gone both ways in that one, but that is certainly something that shows up all the time with older people, and children and grandchildren kind of ignoring them. And so they try to use some tool, usually a will or a trust, as a vehicle to get the kids to pay attention to them, actually. Although I found one show the kids all of their wills, and I showed them the will rather, and show the grandkids the will, and I said, you get this if you do ABC, and then it turned out everything was included in a trust or was transferred by community property, so the will was an absolutely useless document. So let's go over the terms. First of all, mistake, an incorrect understanding by one or both parties. There's three basic types recognized. First of all, the common mistake. Both parties hold the same mistaken belief. If important, it voids the contract, and if it's not important, who cares? Mutual mistake. Both parties are mistaken as to the terms. Court goes with a reasonable interpretation or voids the clause. And typically they try to retain as much of the contract as possible and just believe that part that is a mistaken part of the terms that the parties had. And finally, we have a unilateral mistake. One party is mistaken as to the terms of subject matter, and it's upheld unless the non-mistaken party takes advantage of the mistake. And again, in cases where there's doubt, it's always going to be interpreted against the writer of the contract, which again is the practitioner. So it's in your best interest to make sure there are not mistakes in the agreements. Duress and undue influence, big topic with older people, I find. And once a person reaches 75 or 80, they seem like they are no longer in a social settings with their children and grandchildren, maybe great-grandchildren, and they feel left out, and so they try using tools to get them to visit them, as I mentioned, or pay attention to them, or to be able to live with them. I had several cases in my career where older people wanted to have the kids move in with the kids. And I said, well, you have a big house. Why don't you have the kids move in with you? Then you can tell your kids you no longer have to pay rent. And when I die, the house is yours. And it worked out great in both cases. But this is usually the type of situation where you see duress and undue influence. Duress is a threat of harm made to compel a person to do something against their will or judgment. And again, the magic word is harm. Harm can be defined in many ways. And so you have to, get legal advice on what that means. And again, that varies also by states, probably. And then undue influence involves one person taking advantage of a position of power over another person through the special relationship. Again, I'm not going to visit you, Grandpa, unless you give me your car. That would be an example in many cases of being an undue influence. Now, if nobody complains, that's not a problem. But I think we all are aware, or most of us are aware, that at death, families always seem to fight over the goods, be it small amount of items or a lot of items, be they valuable items or invaluable items or items of no value. There still seems to be a lot of fighting, and the statement I heard many years ago is, in a death, the only one who gets the assets are the lawyers. And that's probably true in many cases. And when I've done estate planning, I can tell you between the lawyers and accountants, they got it quite a bit because there's always disputes. Very rarely do we line up with a harmonious relationship of the family members when any type of assets at all were in the estate. It seemed if you gave every sibling the same thing, one of them would complain because they did something more, like, I took care of Dad the last 5 years of his life. And if you gave something to the person, more to the person who gave the 5 years of his life with his dad, quite honestly, the others are going to say, well, we're all siblings, we all should get the same. So you're never going to satisfy everybody. Your job, of course, is to work with the lawyers, because the lawyers will be writing the trust in the wills, not you. And you should let the lawyers know what you do know about the relationship between the individual who's having the documents prepared and their beneficiaries or potential beneficiaries. Setting aside the contract, ways in which a contract can be set aside or unmade. First of all, void implies the contract never came into existence. And I've had a contract a couple of times where we thought we had agreement, and after leaving, the client maybe found somebody who was less expensive or someone they got along better with, and came back to me and said, I don't think I want to continue with our contract, so we'd rip it up. Voided the contract. If they wanted, I would write void over it, and they would initial it and I would initial it. There's a couple of cases I want to get rid of clients, but the way I generally did it is to tell them that you and your assets and what you're going to do with the assets have outgrown my capability to handle. And quite honestly, I think you need someone who's got more experience and time than I have to work with you. And if you want, I can give you some suggestions. And that just makes them feel good because they're better than I can offer. And I got rid of them. And you're always going to have clients you want to get rid of. I think the worst thing is to keep a client because you need the clients and they're giving you a hard time. And I let one early in my career do that for me for about 6 months, and I finally learned what everybody told me is it's good to get rid of some clients. You don't want all clients. Avoidable type of contract implies that one or both parties may declare a contract ineffective if they want. An example of that is a minor buying something in a store. And a minor, again, is under the age of consent in the state. Some states it's 18, some it's 16, some it's maybe 14. I'm not sure about 14, but I do know some states 16 or 18 is the age of consent. And then unenforceable means imply that neither party may have recourse to court for remedy because it's an unenforceable agreement. Typically that's something where it's illegal, such as gambling contract would be an example for most states. Or doing something which is against public morals, that would be another. such as a contract for selling drugs. I'm not sure there actually are contracts by drug dealers, but I think they're probably verbal, so they don't get in trouble, because I could just see somebody submitting a justification for the payments and business expense on a tax return using as justification the contract they had with the drug dealer. And that wouldn't go over very well, would it? Damages. A normal rule for breach of contract is request for money damages in our society. An aggrieved party may apply for injunctive relief to prevent a threatened breach of contract where such breach would result in irreparable harm that could not be adequately remedied by the money damages. The only ones I can think of something like that is an actress or a wealthy person goes into a jewelry store and finds a special brooch or necklace that's a one of a kind, and there aren't any others like it around, and they buy it and say, I want it delivered to my house tomorrow. Why take it out with it? Or I want it delivered to my bank vault tomorrow. That's probably the answer. And later that day, another clerk in the store sees it on the side, shows it another kind, and sells it a second time. Well, is there been a breach of contract? And if it's found to be a breach, then we would have irreparable harm, and we could get the brooch or the necklace rather than money damages. Again, it depends on all of the facts of the case and what legal jurisdiction you're in as to who would win in that case. But that would be a good example that's very clear of where it's something very unique. Arbitration. If a contract contains valid arbitration clause, then the aggrieved parties must submit the arbitration claim in accordance with procedures set forth in the contract. There's a lot of movement in some areas of our society today to do away with arbitration clauses. They feel that they are very beneficial for the practitioner because of how it works out as to who becomes the arbitrator. Again, I don't want to get involved with that, but always check with a lawyer as to what the status is in your state as to use of arbitration in lieu of legal system. I personally much prefer arbitration. I at one time was an arbitrator, and I find it's faster, it's more relevant for non-legal issues, because a lot of times the issue involved is not really something that a judge is knowledgeable about, and certainly a jury wouldn't know about. Therefore, arbitration with having an expert in the field making decisions is much better. The arbitration decisions are enforceable in the courts, and therefore it's a good way of handling disputes between parties. And an arbitration can be very simple, and I've never been involved with arbitration as a financial planner or as a tax preparer, but I have in the business world. And what we did in the case, we have a dispute on something technical. We would hire an expert, usually a college professor from Caltech, UCLA, or SC, who is an expert in the field, have them as the arbitrator, and we would go in and resolve it that way. We had an accounting problem once, which in a negotiation there was a contract that was a cost reimbursable type. Whatever we spent got reimbursed for, but there were certain rules on that reimbursement, and there was some costs, a significant value, about $200,000, which the buyer said is not one of those costs that's reimbursable based on the clauses of the contract. And we said, well, when we read it, it was includable. So in that case, we got a accounting instructor from USC, and he sat and made the decision for us. Again, these occur usually over a day, 2 days at the maximum, and not where you go to court and you have to wait 2 to 3 years just to get your case heard. So again, I like arbitration, although again, many people in the financial community use arbitration clauses in their contracts, and some states are not looking very favorable towards them. And again, you have to get with your attorney to find out what your state does. Choice of law: contract disputes between parties that are in different jurisdictions and are subject to the jurisdiction that is applicable to the contract. That's the rule. It's a little bit complicated, isn't it? Because let's say I'm in California and my client is in Arizona, and we enter a contract, and we sign the contract in Nevada because we're both in Nevada. Well, okay, what laws apply? And the rule is if a state law is called out in a contract and it is any way related to the transaction, its law applies. So let's say I have my main office in Washington State, and we could have Washington State law, we could have the law of California, the law of Arizona, or the law of Nevada. But let's say we picked Oregon, and neither party of us had any relationship to Oregon, then in all likelihood it would be ignored. If there's no mention of the applicable law in the contract, or again, it's going to be ignored because the courts have no relevance to the transaction, the court will normally apply either the law or the form of the law of the jurisdiction that is the strongest connection to the subject matter of the contract. This is decided by the court where the breach of contract is filed. So typically when the result is where it's filed finds their laws at most applicable, and if they do apply the law of another state, they apply it as it would be interpreted in their state. Again, this is called forum searching and looking for, which we'll cover in a minute. But again, your lawyers are going to be knowledgeable about how to handle this. Don't you try to handle it, what state that should be handled in. Let your lawyer decide that. And as I mentioned, the choice of forum, where the dispute should be litigated, and this is generally followed. And for example, it might be Los Angeles County is where the litigation should be brought. Again, LA County would have to be somehow related to the transaction, or it could be New York City, again, if the headquarters of one of the parties was in New York City, or they had a major office there, which might be for a larger firm than most financial planners have. Next topic we have is damages. There's 4 different types of damages in the breach of a contract for services. First, the compensatory damages given to the party detrimented by the breach, and are consequential and direct damages under that. And you show what your direct damages are, and you can show the consequential damages, and the burden is usually on the person claiming the damages to prove the direct damages as well as the consequential damages. Then there's liquidated damages, an estimate of loss agreed to in the contract. Some states are more preferential or not. Again, when you talk about damages in an agreement, I would always have a lawyer write that for you so that you do comply with your state law. There's nominal damages, small cash amounts when plaintiff has suffered no quantifiable pecuniary loss. And I think that where I've seen that is in where someone's been slandered or libeled, and they really can't prove how bad it was, so they're given damages of $1. And I think there was an excellent book written years ago called L1. I'm sorry, not L1. It was it's a British court. I can't think of it, so forget about it. But there's a whole book written about the involvement of nominal damages in a court case. And unfortunately, I can't think of what it is right now. Then there's punitive damages used to punish the party at fault. Again, this is done by the court. And these are the 4 types of damages we have in our country. Then we also have specific performance, which is really kind of rare. We talked about a few minutes ago, a remedy where the circumstances show it would be unjust to permit the defaulting party simply to buy out the injured party with damages. Best example is when the seller agrees to a sales price, then gets a higher offer from another party later on, which is what we talked about earlier in the jewelry situation, or a necklace. When it's a one-of-a-kind, obviously, that becomes important. Again, I doubt if you run into this in your practice, unless it's, again, it might be that the client came in and asked to have you put into their portfolio certain stock, and the stock takes off and you forgot to put in a portfolio. That might be an example where this might be involved, and you have to go buy that stock for them. Again, it's all how everything's written. And finally, in conclusion, after taking this module, you should see the need for legal assistance in drafting your service contracts with your clients, and also many times with your suppliers, such as you might have a relationship with tax preparers or actuarians or certified financial analyst. In those cases, again, you want to make sure that you're getting the proper legal advice for the type of contract, and don't try to use one contract for all purposes. That's going to lead you nothing but grief later on, because the contract's going to be interpreted against you if you do get in a dispute. Options are available within a service contract, and you can do different methods of handling it, and we've discussed that. We also discussed the remedies available for wrong party, which is basically damages, money. And then I think the last thing is, which I really didn't have a separate charts on, but hopefully you got it from listening to what I was talking about, is the importance of reading and understanding the contract. If you don't understand it, how is your client going to understand it? And it's kind of embarrassing, again, when I did my research with deciding whether or not to be a financial planner, which was the due diligence exercise. One of the 10 people I interviewed was a CFP practitioner. I said, here's my contract to give. And I looked at it and I said, I don't understand this paragraph at all. And he looked at it and he says, I don't understand it either. Well, if he didn't understand it, he wrote it, that could be terrible ramifications for him. I don't know if he ever changed it. He probably should have, or put it more bluntly, he should have changed it, because he was just asking for trouble. If you don't understand your agreements, your suppliers and clients are not going to have to make much of an argument to win a case with you if you get involved in arbitration or worst case litigation. And with that, I'm going to say good luck.